Hello guys, welcome back to my channel When Humanities is Life. In our last video, we learned in details the first part of the chapter on judiciary, and in this video, we will obviously do part 2. And with this video, I will end your syllabus of legal studies. So without much ado, let us start. In India, criminal justice is administered by mainly two courts: the Magistrates Court and the Sessions Court. Now, since we lived under British rule for almost 2 centuries and perhaps more, so our criminal law is also duly influenced by the English criminal law. In fact, the first criminal code of India, the first substantive criminal law in India, the IPC of 1860, was enacted under the British Raj. An IPC of 1860, along with other penal laws, constitute India's substantive criminal law. It also draws a lot of inspiration from English criminal law. Now, after the 1860 IPC, the CRPC, or the Code of Criminal Procedure of 1974, was passed. Now, at this point of time, India ceased to be a colony. So now Indian interests were kept in mind. It was the first priority and not the narrowly defined commercial interest of the colonial government. Now CRPC 1974, it was enacted with primarily three objectives. We'll look into that. Now please don't ask me why is it CRPC. It's just named like this because it's Criminal Procedure Code, but you will write Code of Criminal Procedure. There is only one E here. So the first objective is administration and enforcement of substantive criminal law in India. Secondly, the CRPC of 1974 regulates the working machinery of investigation and trial for the offences that are committed in the nation. And along with the CRPC, there are other legislations like the Indian Evidence Act of 1872 that was enacted to guide the process of investigation and trial by the police and the magistrate in India. Let's look at the hierarchy of criminal courts. At the apex, as I already mentioned in my previous video, and as you all know, we have the Supreme Court, the final authority in deciding legal matters. Below the Supreme Court, we have the High Court. Below the High Court, we have the Sessions Court. Below it, the Additional Sessions Judge, the Chief Judicial Magistrate, First Class Judicial Magistrate, and finally, Judicial Magistrate Second Class. Now let's look at some of the details. Let's start from the lowest ranking court, the Judicial Magistrate Second Class. Now this magistrate is competent to try cases if the offense is punishable with an imprisonment for less than 1 year and a fine of less than rupees 5,000. Now, what are these limits? These are the pecuniary limits that are set on the powers and functions of each court in India. These are the pecuniary limits related to money. Now, above the Judicial Magistrate Second Class, we have the First Class Judicial Magistrate, and he or she, the judge, is competent to try cases which relates to offences punishable with imprisonment not exceeding 3 years and with fine not more than 10,000 rupees. Okay, above that we have the Chief Judicial Magistrate. He can impose any fine. There is no limit on the fine and can impose punishments up to 7 years. Above him or her, we have the Additional Sessions Judge, who can impose punishments as much as up to 10 years. And above the Additional Sessions Judge, we have the Sessions Judge. Now, Sessions Judge, there is no limit on imprisonment and fine. He can impose any punishment. But the death sentence announced by the Sessions Court on any accused has to be ratified or confirmed by the High Court. whichever death sentence he announces, the High Court has to confirm that. The High Court judge has to confirm that this death sentence is just, it's reasonable. This is provided in section 28 and 29 of CRPC 1974. And obviously there is no limit on the powers of Supreme Court. It's limited, obviously, the other organs check it, but the Supreme Court can impose any punishment. It can also impose death sentences, and there is no authority that can check it. It's a final court of appeal. Next we come to the criminal process and investigation. It relates to the prosecution of the accused. Now it can be divided into two streams in India. The first stream relates to the police reports. People go to the police station to file complaint, perhaps the FIR to the police. And there is the next stream, the second stream, or complaints which are filed by private individuals, not to the police. Okay, so in this case, the prosecution is conducted by the director of the public prosecution. He or she is a state authority. This state authority, it also um, appoints certain lawyers, and they are called the public prosecutors, the PP. This lawyer represents the state, and on behalf of the state, it perhaps conducts the cases. They are basically lawyers and nothing else. Okay, but on behalf of the state. Mostly they're against the accused. Sometimes when someone has committed a crime against the state, then the PP is appointed by the state to fight the case on behalf of the state. And details of this process is given in section 225 of CRPC. What does this section say? It provides that every trial before a sessions court shall be conducted by a public prosecutor. You have just now here read about the sessions court right below the High Court, perhaps the highest criminal authority at the district level below the High Court. So in the sessions court, every trial has to be conducted by a public prosecutor. That's all. Nothing else is there in the first stream. In the second stream, we have private complaints. The cases that are instituted on the basis of private complaints. Now, private complaints can be filed by private individuals, and they often engage their own private lawyers with respect to these complaints. Now, section 138 of the Negotiable Instruments Act of 1881, it provides a substantive example of this provision of private complaints. Okay, now we come to the three stages of a criminal procedure. Suppose someone has committed a wrong towards a person. Now the aggrieved person is filing an FIR to the police. This will start the entire process. Now what will happen? First of all, the police will investigate. Then there will be an inquiry, and finally the wrongdoer is going to have a trial. He or she is going to try it. Yes. All right. So let's start with the first stage, which is investigation. Basically, it is the collection of evidence by the police. That's the objective of investigation. The purpose is for inquiry and trial. The police collects evidence for the purpose of an inquiry or trial. It's a preliminary stage inquiry. Preliminary means initial. Preliminary stage inquiry conducted by the police, and it starts after the recording of a FIR. What is an FIR? The first information report. Okay, in section 154 to 155 of the CRPC states that investigation starts upon the filing of the first information report or the FIR. And when a person approaches the police with a complaint, the police of that concerned police station is duty bound, is compelled to file the FIR. There should not be an excuse. Now, in reality, there are certain things that happens which should not happen, but obviously the law makes sure that the police is bound to file the report. And there are 7 steps of this investigation, which primarily consists of ascertaining facts and circumstances. First step is the collection of evidence. Various evidences related to the offense are collected by the police. Second point is that the police inspects the place of occurrence of the crime. The police inspects inspection of the place of occurrence of crime. The police inspects that area. Third step, ascertaining facts and circumstances. F and C have written in shortcut facts and circumstances by the police. Ascertaining facts and circumstances, as in the police finds out what has actually taken place on the day the crime was committed. All right. Fourth, discovery of any article or object used for the commission of crime, perhaps a murder. Then suppose a person was murdered by a gun, perhaps, and the gun was hidden somewhere. During this investigation, it is the duty of the police to find out where the gun is, because the gun is an article with which the crime has taken place, and such articles has to be discovered by the police when during investigation. Then arrest of the suspected offender. Obviously, we are all familiar with movies and web series regarding all these things. That shouldn't be an issue. Sixth point, interrogation and examination of the witnesses or the accused, and their statements are taken in writing. This is a very interesting part of the syllabus, because we are all very much aware of all these things from what we see in our mobile and computers, whatever. So interrogation and examination of various persons and the witnesses, including the accused, taking their statements in writing. And the last point, congratulations that you reached the seventh and the last point, search of places or seizure of things considered necessary for the investigation and which is also considered to be important for the trial. So search of places and seizure of things. And investigation ends when the police reports to the magistrate. That's it, done. Now we come to the second part, which is inquiry. What happens in an inquiry? Now, the definitions of each of these stages I have written in black ink so that you can understand. Inquiry refers to the proceedings before a magistrate prior to the framing of the charge which does not result in conviction. Now, let me tell you that there is a rule that after within 24 hours of arrest of an offender, the person has to be presented before the magistrate. That's a fundamental right that we have as Indians. And that presentation before the magistrate is not no one other than the nearby judge. Okay, that is what refers to the inquiry. And during this time, the person is not really convicted or acquitted. He or she is simply presented before the magistrate. The magistrate, sifts and weighs the evidence, finds out whether he or she has done anything or not. That's what it is. It's a proceeding before a magistrate prior to the framing of charge. We will know what's the framing of a charge right now after some time. Now, the magistrate can either find that the accused has not done anything, so he or she is discharged, or he or she, the magistrate can find that the accused has done something and is committed to the sessions as in the proceedings. Now, section 2 part G of CRPC states that inquiry refers to any process before the court which is not a trial. So the judicial adjudication of a person's guilt or innocence does not take place in inquiry, it takes place during trial. If no prima facie means on the face of it, as in a real case, a substantial case is not made out against the accused, he or she is discharged. The third stage is trial, which is, as I said, the judicial determination of a person's guilt or innocence, and it ends in either conviction or acquittal. We also follow the accusatorial model. This is a very beautiful concept, What happens? There are two parties. Obviously, the prosecutor who prosecutes the offenser or the accused, and the defendant who defends. Suppose I have done something, I am the defendant, and the person who is against me, to whom I have inflicted the harm, he or she is the prosecutor. Now, the law requires the prosecutor to prove the case against the defendant, and the uh, degree of proof should be beyond reasonable doubt. We have a presumption of innocence. The law will presume that the accused, the defendant, is innocent. The prosecutor has to prove it beyond reasonable doubt that the defendant has indeed done something extremely wrong to him or her. After the three stages of a criminal trial, next we move to the three types of criminal trials. There are three main types: warrant cases, summon cases, and summary trials. What is a warrant case? Just know the degree of seriousness. Now, warrant cases are the most severe types of offenses. In summon cases are the less serious ones, and summary trial are the petty ones, extremely less serious ones. Now, the warrant cases are those cases which relates to offenses punishable with either death, life imprisonment, or a term more than 2 years. In summon cases cannot have punishments which is more than 2 years, and in summary trial, no sentence of imprisonment for more than 3 months can be given. As I said, they are mostly petty offenses. Now, let me tell you, this article is actually not important. If you can learn, it's very good. Now, again, we come to the same thing. There are two types of, there are two ways in which complaints in warrant cases can be filed, either on the basis of police report or on the basis of private complaints. All right, so that's all with warrant cases. And if there is a term of imprisonment more than 7 years, then the proceeding shall take place before the sessions court. In summon cases, no there is no need to frame charge at all. There is a notice that is given to the accused, based on which the accused comes to attend the court. You can understand from the name summons. It said that this person has received a summons from the court, so the person has been tried for a pretty less serious offense, and has been called by the court. Okay, then the notice gives substance to the accusation. So, what is the accusation? That can be reflected from the notice. And obviously, the judge can transform a summon case into a warrant case. And what do you mean by summary trials? In the case of summary trials, no sentence for more than 3 months can be imposed, and the second class judicial magistrate cannot impose a punishment for more than 6 months. Alright, guys, let us move on to the next part: distinct stages of a criminal trial. Now, I know most of you will face a challenge to remember this portion, but I've made I think pretty good notes so that you can remember it. And I'm also going to propose that you should remember this part through mnemonics. You can make your own. I have made a little one for you. So, there are 6 distinct stages of a criminal trial. And how can you remember that? FRS DFJ. I know it doesn't make much sense to you, obviously, but I can't think of anything else right now. First of all, F, framing of charges and issuance of notice. R, recording of prosecution evidence. S, statement of accused. D, defense evidence. F, final arguments. And J is the judgment. Now, see, judgment is often treated as a stage which has gone beyond a criminal trial, so I have not marked this with them. But obviously, you have to write it when the question is on the 6 distinct stages of the criminal trial, so you have to include that as well in your answer. Let's do it. All right. First of all, in the first stage, what happens? It's the beginning of the criminal trial, and the judge sifts and weighs evidence, examines the evidence to see whether a prima facie case emerges or not. Prima facie, as in I just now explained to you, um, a substantial case which is not vague. Okay, if the materials placed are sufficient to conclude that there was a commission of an offense, then The judge frames the charges, and if there is no sufficient ground, then the accused is discharged. At the end of this stage, the the charge is read out to the accused and explained, and the accused is entitled to answer. The second stage is recording of prosecution evidence. Who is the prosecutor? I'm not going to explain. You will write it in the chat box. I think you know. So on behalf of the state or on behalf of the claimant, the prosecutor will now, obviously through the lawyer, present their witnesses, and the statement of the witness would be examined on oath. There is an oath that I will not lie, something like this. This is an oath, and this is called examination in chief. The accused is examined by the prosecution, and the witnesses of the prosecution is also cross examined by the accused, the defendant's lawyer. And section 309 of CRPC states that this stage in this stage there would be an expeditious trial. What do you mean by the term expeditious? It's speedy. One after the other, the witnesses are going to be examined. Now, do you know the reason why this happens? Because in certain grave offenses, sometimes the witnesses are tampered with, sometimes the witnesses are killed, or some other serious things happen. So once the examination of witnesses have started, one after the other, in an expeditious way, the entire trial will take place. That's it. Third stage, statement of accused. Now the accused will answer or will present its own points. The accused can be examined at any stage of the trial by the court. And what is the purpose of this examination? The accused is given a reasonable opportunity to explain incriminating circumstances as in certain circumstances which forces the accused to be a witness against himself or herself. Now you see how beautifully the Indian constitution and the legal system has given safeguards to all the citizens of India to prevent some wrong deliver of certain judgments against us. We should not be prosecuted without reasons. It is said that someone can be left from actually being prosecuted even though he or she has committed something, but one innocent person should not be prosecuted because of the mistake of the court. That's a very beautiful philosophy of the Indian constitution and the legal system. And this statement and this examination of the accused, it is mandatory. It's mandatory to examine the accused after examining the prosecution. Now I'm going to just repeat it. I don't know if you are getting confused here. Prosecution or the prosecutors refers to the person or the state, perhaps the person who has filed the complaint against the defendant. And who is the defendant here? The accused is the defendant here. The accused is the person against whom the entire proceeding is taking place, and the accused here will be examined so that the accused has a reasonable opportunity to explain any incriminating circumstances arising before him or her. The next stage is the defense evidence. Okay, what happens here? Again, after taking the evidence of the prosecution, examining the accused, again hearing the prosecution and defense, if the judge considers that the accused has not done anything, then the accused will be acquitted. What is acquittal? Acquittal as in the granting of bail, as in the person is released, the person is left, the person can go away now, or the person won't go away because a prima facie case is there, the person will have to remain in jail and will be prosecuted. So, or the proceeding will go on further. Next, what happens? In the absence of evidence, when the accused is not acquitted, a defense has to be entered, and evidence will be adduced in its support. So now the lawyer of the accused will come up, will lead the defense evidence, and anything can be said in defense of the accused that no, my client has not done this. Such things do take place often. All the parties are represented by lawyers. Now, in India, what happens? Most accused do not lead defense evidence. Why? Because India is a common law country. It follows a common law system. I explained this in the in the previous section. The burden of proof in India is on the prosecution. If I am here with a complaint against a person, I have to explain that the accused has indeed done something. So I lead the defense evidence in India. The burden is casted on me, and the degree to which I have to prove the defendant's mistake is beyond reasonable doubt. I have to explain it entirely that the defendant has done it wrong. And then the last stage of the trial is the final argument. What happens here? The prosecution sums up the case, all the details are explained, and the accused is entitled to reply. The accused will say either he or she has done it, he or she will accept it, or will say, no, I have not done. And the last stage, which you have to mention in your answers, but which is not really treated as a stage of a criminal trial, is a judgment. Here, the judge pronounces the judgment. And there are two different concepts that you have to remember here. First, discharge, and then acquittal. Now, under CRPC, the accused can be withdrawn from the trial at any stage with the permission of the court. Often, such things happen. The accused can receive a bail. So, discharge is when the accused is allowed to be withdrawn before the framing of the charge. Before this first stage, if the accused is allowed um, to be left out, then this withdrawal will be termed as discharge. And if the person is withdrawn after the framing of the charge, in these stages, if the accused is taken back or withdrawn, then it is known as acquittal. Acquittal as in discharge of the accused, or the opposite of acquittal is conviction, as in the person is set into imprisonment or fine, or in the extreme cases perhaps is sentenced to a death sentence, though it's very rare in India right now. Okay, so now we come to bailable and non-bailable offenses. Try to understand the concept. Bailable offenses are those offenses in which the accused can obtain bail. What is a bail? Bail is a release order. And in the case of non-bailable offenses, these are so serious offenses that the accused cannot obtain a bail. Imprisonment is generally more than 3 years. And in the case of these non-bailable offenses, there is a very important sentence about it, that bail is not a right in the case of a non-bailable offense, but a matter of judicial discretion. Judicial discretion, the court will decide. And there is also a concept of an anticipatory bail. And the section is 438 of the Code of Criminal Procedure. This section, guys, you have to remember. I tell you the important ones, this is important. And anticipatory bail, it can be granted if a person has certain reasons to believe that he or she may be arrested in the future. Because of this apprehension, I can already approach a court and say that if I am arrested, I have to be released immediately, because I know I can be arrested. Now, there are certain debates about whether this should exist or not, and all the rest of it, because of certain misuse by criminals. Sometimes certain powerful people who have committed some crimes, they often take this anticipatory bail and often evade getting into the prison. Such things shouldn't happen. And there are various considerations that the court takes. First of all, the fourth things the court considers: nature and gravity of accusation. Obviously, we don't want murderers to take anticipatory bail and evade law. Then antecedents. Antecedents as in the various reasons or possibility of the accused fleeing justice, just what I said right now. And the court will also consider if the accusation is aimed at humiliating the applicant. Now, Again, we have two more concepts of offenses: cognizable offenses and non cognizable offenses. And I purposefully written this in the same page so that you don't get confused. People often get confused in bailable and non bailable and cognizable and non cognizable offenses. Now, non cognizable offenses, alike non billable offenses, are no, not alike, actually, I'm so sorry. Non cognizable offenses, contrary to the non bailable offenses, they are less serious, and imprisonment for less than 3 years are imposed on such non cognizable offenses. And cognizable offenses, on the other hand, are the very serious offenses like murder, robbery, dacoity, rape, kidnapping. All these are cognizable offenses. Now, any offense which is punishable for not less than 3 years or are serious offenses, those are cognizable offenses. And what is the source from which we know about this? The first schedule of the CRPC. And there are certain exceptions too. Exceptions are offenses related to marriage. I want you to know the exceptions in details, guys, because questions come from these areas. Exceptions are offenses relating to marriage, like bigamy and adultery. Bigamy refers to, a person having more than one wife. And adultery means sexual relations outside the wedlock. Such offenses are punishable for more than 5 years, but still are non cognizable. They are non cognizable offenses, as in less serious offenses. Why is this an exception? Because in non cognizable offenses, generally imprisonment is for less than 3 years, and in more than 3 years is in the case of cognizable offenses. But even though bigamy and adultery have imprisonment term for more than 5 years, still these are uh, non cognizable offenses. And next we come to the a small portion of juvenile justice. Now, under IPC, Indian Penal Code of 1860, criminal responsibility starts at the age of 7 years. But if a child aged between 7 to 12 years does something criminal, he or she is free from the criminal liability if it is proved that the person is not enough matured. If the person is not enough matured and does not have the understanding of the nature and consequences of the conduct that he or she has committed.